Hey, what's going on? Have you heard about our radio show? That's right, there's a medical marijuana radio show, and I do it for you every Thursday night at 8:30. And there's a medical marijuana radio show, and I do it for you every Thursday night at 8:30.
Hello, this is Stuart Richland here from 420 Law Office and here on the YouTube channel. I've been a lawyer here in Southern California for 25 years, representing medical marijuana collectives, co-ops, dispensaries, patients, and landlords and doctors for about 5 of my 25 years. And today, I would like to congratulate Richard Lee and all of the people who put forth Prop 19. Although I wasn't a backer of it or a creator of it, I wound up voting for it and supporting it and putting out quite a few YouTubes in support of it. And I think that it has elevated the debate, and I'll be darned, we almost did it. 46% of the voters said yes to this measure, and now there is going to be another measure in 2012, and it's going to keep going until marijuana is finally taken out of the position that it's in and put into its rightful position as a reasonable intoxicant. But the purpose of today's session is to once again underline the rules about medical marijuana. So many people contact me and ask, how can I open a medical marijuana collective, co-op, dispensary, garden, or delivery service? And the basic answer is that, well, you really can't. It should be formed by a collective or co-op of patients. So a group of patients may get together and form a collective. And a collective, the preferred vehicle, must be nonprofit. And even if you follow all of these state rules perfectly, federal law still holds that the activity is a felony, a serious felony with up to 5 years of prison and $250,000 of fine for even one sale or the cultivation of one plant. And when the sale or cultivation exceeds 99 pounds or 99 plants, then the federal sentencing guideline goes up to 20 years. So it's a very serious issue and a serious decision to make to engage in civil disobedience when your own freedom, property, and money could be at stake. So you must fully understand federal law, not just those things that I just explained, but other aspects like the complicated taxation handling of medical marijuana by the federal government, the relatively easy state handling by federal tax authorities, by state tax authorities, and also things like the description of how the forfeiture rules work federally. Once you understand federal law perfectly, then you can see how it intertwines with or fits over state law. Remember, federal law must be looked at as well as state law. You can look at the two of them and see how they overlap and where they're different and where they complement each other. Because federal courts and federal judges still have jurisdiction over the activities of everyone in every county in the United States. So it's a weird situation that if a federal law enforcement agent took you to a federal judge for doing activities for your collective that are perfectly state legal, that same activity could be considered a crime in that federal courthouse in your county, whereas in the state courthouse in your county, that activity could be perfectly defensible as the activity of a California collective. So, therefore, it's a very difficult thing to understand. You should get competent legal counsel that are experienced, and that's what our office does. And after helping you understand federal law, your attorney should then go through a very detailed analysis of state law. State law is generally best summarized by starting with the Attorney General's guidelines written by Jerry Brown, soon to be our governor again, and he wrote those in August of 2008, pursuant to the mandate of Prop 215, which said that the Attorney General should do some guidelines. Remember, it took quite a few years for that to happen. And although it doesn't have the force of law, recent cases such as the Hoconadell case and other cases relating to other areas of the law say that the Attorney General's guidelines are given considerable weight by the judge, although they're not governing or controlling on the judge. They're given considerable weight. So the first starting point to understand California law is to understand those guidelines. And although they are 11 pages and it's easy to read through it at a sitting real quick, it is deceptively deep, and you'll have to reread that many times. There are a bunch of other things you'll need to look at too, and I have organized that information for you into a paperback book. I had the book with me today in court because out of nowhere the city attorney was suggesting that no one in the city of LA had allowed for collectives and dispensaries. And so I showed the judge a copy of the motion of September 22nd by Mr. Zine at that time, which stated that what the city's position was at that time. In my book, it's in my book as well as a lot of other things that I want you to see. One of the things in the book here is my comic book. The comic book is a full-color visual way of describing the law of medical marijuana, and it's followed by the Attorney General's guidelines. And then in between is a document that I created to help you understand the interplay of the different aspects of California law, how collectives work. After the guidelines, you can see an excerpt from the Margolin Guide talking about the case of Ursizano, which describes the proper collective agreements for a collective. And then there's a bunch of other stuff you need to see. Here's the federal sentencing guideline. A lot of these things are on my site for free, but when people come to see me in person, I am able to really go in depth and transmit a lot of understanding. Here's the couple summaries of some important cases. For instance, here's this horrible case, Ross versus Raging Wire. This is the case that says that there is no protection for employees with reference to their medical marijuana use as far as pre-employment screenings may be concerned. So that's an unfortunate decision. Here's a copy of a letter that was signed by the late Senator Ted Kennedy asking for the release of some medical marijuana for research, begging the Attorney General for medical grade marijuana to be used, and this was before he died, and it was also signed by John Kerry, 2 senators, and they still have not been able to get medical grade cannabis available for research. Here's a copy of the United States Attorney General's memo regarding the federal government making it a low priority to prosecute medical marijuana patients. Here's a copy of the special notice from the State Board of Equalization describing the taxation here in the state for medical marijuana, and on and on. So I think you'll find there's a whole bunch of stuff in here. I can't wait to get it in your hands. I don't sell the book. I make the book available only to clients in the context of a consultation here in my office, and that's covered by the attorney-client privilege, as are all of the communications that you have with your attorney. And remember to only use a licensed attorney and never to accept legal advice, which includes understanding any law and drafting any document or understanding the legal significance of any document, not just going to court. So make sure you use a licensed legal professional. And give us a call anytime you need some assistance with understanding medical marijuana law. You can reach me at 888-420-LAW-1. That's 888-420-LAW-1. Take good care.
Hey, what's going on? Have you heard about our radio show? That's right, there's a medical marijuana radio show, and I do it for you every Thursday night at 8:30. In fact, the podcast is available ahead of time every week, and you can get it at 420lawoffice.com. Just click 420 Radio Show, and you can download the podcast, and you can subscribe by clicking a button, and it's going to show up in your phone or in your iPod. So be sure to check out 420 Law Office Radio. I think you'll find it's rocking. All right, take good care.